All right, so as Rusty said, I'm Jeff Joseph. A little bit more about me. I have done nothing in the law except for immigration. When I graduated law school, I was going to be a public defender, but so was my wife. And the way that that system works is you're put on a list, and whenever a position comes up anywhere in the state, you go. And so I didn't want to be separated from my wife right after we got married, so I took a job in corporate immigration, not knowing what that was or what it meant. But I had a lot of trial experience, and so I negotiated with my boss to let me start a little removal defense / family immigration practice within her corporate immigration firm. And I spoke Spanish, so I went down and volunteered at the detention center and started taking on bond cases for free. And then once people bonded out, they'd hire me. And within a year, I had more clients than she did. And so I left and started my own practice and did that for 25 years. With my wife, we started our own practice and built a practice together over 25 years. It was a full service practice, so we did everything. Everything from corporate immigration to asylum seekers, to citizenship, to family, to removal defense, to federal litigation, the whole gamut. Just before COVID, I got recruited by Barry Appelman Leiden, which is a global immigration firm. They're the second largest immigration firm in the world, offices in the US and all over the world. We do both inbound and global immigration. So very, very large corporate clients with massive immigration programs. And so before I took on my current role, I was managing a client with 1,200 foreign nationals. So very large immigration programs. In January, when the administration came into power, I shifted over to our government strategies team because we were going, obviously to have more need to focus on worksite, enforcement, compliance, and also federal litigation when necessary to sue the government. So I exclusively do that now. I exclusively do worksite enforcement and federal litigation, and it's kind of a dream job for me. It's kind of what I love doing. So very happy to be here. In 2 weeks, I will become president of our bar association, our National Bar Association. Our annual conference is being held here in Denver in 2 weeks. And so, in that position, I have a lot of visibility over what's happening in the administration and on the ground. Anecdotally, through the rumor mill, through the trend trackers that we have in our association. So, a lot of what I'm going to say today is not based in necessarily actual policies, but it's based on what we're actually seeing happen on the ground. Okay. All right. So, what we're going to talk about is generally just kind of worksite enforcement and employer compliance, and how to proactively prepare yourselves in the event of any sort of enforcement action. So and by the way, if you have any questions, you don't need to wait till the end. Feel free to ask me questions throughout. We'll keep it interactive as much as possible. So the context of this is a bunch of executive orders that really intensify internal immigration enforcement. So if you think about what was happening prior to the election, right, it was a lot of chaos at the border, a lot of irregularity, a lot of illegal crossings, irregular enforcement. And the last administration attempted to deal with that through a process called parole, right, which is not an admission into the country. Doesn't provide you necessarily legal status, but it does allow you to sort of be admitted into the United States. And if there is a pathway to relief, such as asylum or a family member, you may have the option to do that. But otherwise, you're just sort of in this legal limbo. And so it was a program that did allow for regular pathways rather than illegal pathways, but it also created a whole bunch of people who were in this sort of limbo status, right? And the courts are overwhelmed. And so there's no doubt that enforcement needs to be a priority. I think the American public, when they voted and went to the election box, they sent a mandate to this president. It was the most important voting issue in the exit polls, immigration was. And so there's definitely a clear mandate that people wanted control of the border and they wanted the chaos to end. But what has happened is the external chaos at the border has now been replaced with internal chaos internally. And that's a result of all the massive amounts of executive orders that were issued, literally starting on day one with the administration. So some of those enforcement orders, it really expanded ICE authority. So for example, declaring a national emergency at the southern border, right? By declaring a national emergency at the southern border, that gives the executive the power to do things like deploy troops to the border, to deploy Coast Guard to the border, to use military, drones, other types of technologies. It also authorizes the administration to ask for different types of appropriations, like appropriations in the national security budget and other things that allow them to sort of access other pools of money. It increased ICE presence in all industries, but also in industries that have traditionally been protected. So one of the things that has always existed is what they call the sensitive locations policy, where ICE has sort of coalesced and agreed not to take enforcement actions at things like schools, hospitals, churches, to a great extent even private institutions, some private institutions, but that sensitive locations policy has been eliminated. So there really is a focus on enforcement everywhere at all times against everyone without discrimination. Let's see. Revoked federal funding from non-compliant jurisdictions. So we've already seen, what they call sanctuary cities. Have their federal funding revoked as sort of an implicit threat to get on board, or we'll come after you, right? And we've seen cities push back against this. We've seen cities sue about this, but we have not yet seen massive sort of enforcement actions on it until really the past couple of weeks. And now for the first time, we are seeing what I will call raids. And I think raids is a legal term of art. Raid means ICE comes with a warrant, a judicial warrant. That's what a raid is, okay? And if they have a judicially enforced warrant, it's a raid. And we've seen a number of raids happen in the past couple of weeks against restaurants and other businesses, mostly in sanctuary cities. So, stay tuned. My prediction is it's coming soon to a town very near you. So, we have to watch out for that and be prepared. So we're going to talk about what the employer risks are in this situation, but obviously it's an increased risk of I-9 audits. It's an increased risk of potential E-Verify investigations and audits. If you do E-Verify, it's an increased risk of raids. And you have to be prepared by having internal protocols that have been checked legally, but also that prepare you in the case that something like this happens. So we'll talk a little bit about that as well. Okay, so the first question you want to ask if somebody shows up is, why are you here? Because not every federal officer who shows up at your work site is there to do an arrest, right? There are a number of different officers, federal officers, who may show up to do something related to immigration. So for example, wage and hour, right? Both state and federal wage and hour officers may show up to see if you're doing things like complying with the minimum wage requirements or complying with the Davis-Bacon Act if you happen to be subject to Davis-Bacon contract wages, compliance with FMLA requirements. A lot of these wage and hour complaints are driven by complaints from workers or disgruntled employees who've been laid off. But wage and hour is one of the entities that may show up at your work site. Another one is FDNS, Fraud Detection and National Security. In every immigration petition that is filed, it is run through what's called FDNS, or Fraud Detection and National Security. And they're looking for the indicators of fraud mainly, but also looking for anything that potentially triggers national security. Every immigration petition is run through FDNS. And it is this administration and their executive orders has instructed the agency to conduct more on-site investigations before they approve petitions. So if you're an employer that happens to participate in the H-2B program or the H-1B program or any of these other sort of visa programs, you could anticipate that you may see FDNS show up at your job site to make sure that you're doing the things you've said you would do in your petition. And then the one that we're going to talk mostly about today is Immigration and Customs Enforcement. The worksite division is housed under Homeland Security Investigation. So there's Department of Homeland Security, which is sort of the umbrella organization, and then underneath Homeland Security is Immigration and Customs Enforcement, and Homeland Security Investigations is the wing of ICE that does worksite enforcement investigations. So they're the ones that are going to show up at your job site if they're there to conduct any sort of administrative search or a judicial warrant, okay? Even if you just get a 9-9 audit, they're the ones that'll issue you the notice of inspection for an I-9 audit. In big time raids, we've also seen Joint Terrorism Task Force involved, we've seen the FBI get involved, and we've seen the DEA get involved. I will tell you that my experience so far with this administration is if they're coming with a warrant, a judicial warrant, there's bad stuff happening at the job site, right? Go ahead.
Sir, I've seen on TV where, they've raided, as you mentioned, restaurants, things of that nature. Has that happened on job sites in this market?
In Denver? There have been 2 reported ones, but they were only looking for a particular individual.
Oh.
They were not a full-blown worksite investigation. We came with a warrant for one individual. That still can turn into a raid, and I'll talk about how that happens, but both of the cases that have been reported in Denver were individual arrest warrants, serving individual arrest warrants.
Thank you.
The ones that are being reported more globally, we've heard of cases where the employer is alleged to have participated in the knowing hire of mass amounts of workers. Another employer participated in actual fraud on the visa applications. And then there was another employer that there was a drug raid happening within the job. Okay, so all of these came with Immigration +++, which is the reason there was a judicial warrant attached, and I'll talk about a judicial warrant later, but I hope that provides some comfort that, they're not coming after all employers. If they're going to go through the effort of getting a judicial warrant, there's something happening, and a judge has to sign off on that, okay? So that should be some comfort.
Can they show up without a warrant?
Yes, and we'll get there. Okay, so that's why they're here. Those are the different officials. So the first question in your mind, if somebody shows up at your job site, is, who are you? And you are perfectly within your right to ask for their name, their identification, their business card, their cell phone number, their badge number, document it, write it down. I always advise employers to have 2 people present. Whenever there's a worker, anyone that comes to your work site, have 2 people present. One that engages with the officer and the other that completely documents the interaction. Record it. There's no prohibition on recording the interaction. If you want it to be admissible in court, you have to ask the officer if you can record the interaction. If the officer says no, you can decide whether to record it or not. But there's nothing prohibiting you from recording it under federal law. And usually officers are okay with that in the situation, and you see that because people are recording things all the time.
I have a dumb question. If you ask to record it and somebody says no, can you transcribe it from the recording and just write down what was said, utilize it for your notes?
Yeah, I mean, the issue with recording is whether it's admissible in court, right? And the only way that it's admissible in court is if the person is essentially consented to the recording. Now that does vary from state to state and even from state to federal court. So I don't know the specific legal answer to your question. But I think the key is that if ultimately you think that you might want that to be admitted in court, you want to have the person consent. Don't just surreptitiously record it. Okay, this is something that I think is really important for you all in your industry, and this is the distinction between public spaces and private spaces. So, private spaces, if ICE comes without a warrant, they have absolutely no right to your private space. You can turn them away and tell them to pounce on it, to be honest with you. They have no right into your private spaces without a judicial warrant. But I think it's a really tricky issue when you're working on a job site, what constitutes a private versus a public space. I have noticed, and I don't know if this is related or not, but in my neighborhood where there's a ton of remodeling happening right now, every job site has a barrier fence that says private keep out on the barrier, all the way around the property, with signs that say private keep out. I don't know if that's related to a desire to keep their work site protected, but I'd like to think it is, and I think it's a great practice. Another thing that I think is a great practice is to have your foreman or your project manager require employees to check in and check out every day, so that there's not badge control. You really can't do badges on a work site. If you were a different kind of industry, I'd tell you immediately go to badge access and lock everyone out. You obviously can't do that, but you could have your foreman, your project managers require employees, and there may be other reasons to do that as well, by the way, but have them check in and check out so that you have a log of who's able, eligible to be admitted to the work site. So that ultimately, if you have to litigate this issue of public versus private spaces, you've taken efforts to make it as private as possible under the law. You can't control your employees once they go on the public sidewalk, or even once they go out the street, right? So ICE is perfectly able to stay outside of the work site and wait for them there. There's nothing you can do about that. Any questions about public-private spaces? I think it's something that you all should probably strategically think about as an association of ways that you can make your space private in the context of a work site. Okay, so what are your privacy rights? What are an employer's privacy rights? Well, they're the same as any other person under the law, and a person applies to both individuals and companies and corporations, right? So you as companies, you as individuals are persons who are protected under the Constitution. And when we're talking about privacy, we're talking about the Fourth Amendment. So the Fourth Amendment provides a reasonable expectation of privacy, and if a law enforcement does not have a judicial warrant, in other words, has no warrant, they either have no warrant or they presented an administrative warrant that's not signed by a judge, they're only allowed to enter public spaces, okay? So if they have no warrant or they only have an administrative warrant, your expectation of privacy is that they cannot enter your private space. They can only enter public spaces, and that's protected by the Fourth Amendment. There's a whole bunch of really interesting case law called curtilage case law that is about whether, like for example, a detached garage has the same reasonable expectation of privacy as a home. And the case law is whether it's part of the curtilage of your property. So even being in your own home doesn't necessarily provide you the same type of protections, for example, if you're in your garage or a detached structure. But the reason the private versus public spaces distinction becomes important is because the Fourth Amendment privacy protections apply to those private spaces, not to public spaces. Okay? You can refuse them entry. You can tell them they can't come into your public space. Okay? I'm sorry, your private space. Private space, not public space. All right. Any questions on that? Okay, so let's talk about warrants, because this is the most important piece of the puzzle. This is the distinction from which all other policies and protocols should follow. So when ICE shows up, they're either going to have no warrant or they're going to have some sort of warrant. If no warrant, then you tell them what I would say, and I told you to tell the council. Obviously, that's not the correct legal answer. The correct legal answer is, thank you. If you can leave me your information, we will check it with our legal counsel, and we'll get back to you. That's it. That's all you have to say. And wish them a nice day, give them a donut, and send them on their way. But that's all you have to do. And then immediately you take that, and your counsel will tell you whether or not to respond or to take further action on it. But at that point, you do want to consult with a professional about what to do if ICE showed up at your job site. If they have an administrative warrant, and by the way, the first thing you do, obviously, after you've asked them for their identification, taken down their badge numbers, you ask them if they have a warrant. And then if you look at the warrant, and you'll be able to tell from the warrant whether it's a judicial warrant or an administrative warrant. If it's an administrative warrant, it's going to come from Department of Homeland Security. It's going to be from the agency, maybe from HSI or Immigration and Customs Enforcement, but it will be from the agency itself and signed by an agent, not by a judge, okay? A judicial warrant looks official. It looks like an actual court document. It's signed by a federal district court judge. Okay, a federal district court judge has to sign a judicial warrant. That's really important because in order for a federal judicial warrant to issue, the government must have made a compelling case to get it issued, right? So they have already vetted the case through the U.S. Attorney's Office up to the federal judge, and the judge has determined that there's reasonable cause to issue a warrant for arrest of an individual or deceased documents. So that's why a judicial warrant needs to be taken very seriously, is because it comes with the imprimatur of a federal judge, right? So if it's a judicial warrant, you comply. There's no question, right? You may still refuse to consent and orally say, I understand this is the warrant. I want to make clear that I'm not consenting to the search, but I understand you have a warrant and may proceed, right? So I always tell clients, you never consent to anything, even if they have a warrant. Because if that warrant is faulty for any reason and you've consented, then it doesn't matter, right? You've given them the opportunity. So no matter what, you always refuse to consent when they ask you to do something. Okay, so judicial warrant issued by a federal judge or magistrate, it authorizes ICE to enter private property, okay? So it allows them to enter your private spaces without consent. It must, however, state with specificity and particularity the private spaces to which they have authorization to enter, okay? They don't get access to just walk around your property and talk to whomever they want to. In fact, you should escort them. Two of you should escort them at all places, at all times, okay? Because you want to document that what they're doing is consistent with the warrant. If they try to do anything that is inconsistent with the warrant, you need to register your objection immediately and say this is not covered by the warrant. You do not consent, you're not authorized to go into this. But don't resist. Let them do it, right? Register your objection, register your lack of consent, but don't resist. That's when you get in trouble for harboring and obstruction and a whole bunch of other conspiracy felonies that you don't want to have to deal with.
So, as a question directly related to that, how much time does one have to be able to read a warrant? Because you'd be seeing it for the first time, you'd be having these people standing in front of you, and if one is going to escort them around the property or a job site, you need to be familiar with what the cause was in the warrant. Right?
Yeah.
So you have time, I assume,
You
to
do.
review the document before you even say, I'm not agreed to consent,
Yeah.
but I understand you have this warrant and it allows you to come into this.
100%. Yeah, and I think, listen, if they show up with a warrant, it's the most important legal document that they're going to have. It is perfectly reasonable for you to say, do you mind if you just have a seat for a couple of minutes while I look at the warrant? And, you may not be the person that's even served the warrant. It may be your receptionist at the front desk, right? We'll talk about the protocols and phone trees and everything else. But there is no reason that your receptionist should be accepting a judicial warrant on behalf of your company, right? So it is perfectly appropriate for the receptionist to say, thank you, sir, would you like a glass of water? Can you please have a seat while I contact the person that can be responsive to your complaint, right?
And oftentimes we're working in private residences. When is the appropriate time to open the door to an officer?
Never, right? So you never open a private door to any officer until you ask them to produce a warrant. And usually what I do is I ask them to show it in the window or slide it under the door, but you never let any officer into your private space, period, without a warrant.
Really quick distinction there, because it's not construction company's private space.
Well, that's
We're
just
coming out of
true,
private.
right? So I thought about that because you don't really have the right to invoke privacy.
Right.
And so there's a couple of thoughts that I have, and I don't have a legal answer to this, to be honest with you, it would require legal research. But one idea is to cover that in the contract, where with the homeowner, that the reasonable expectation of privacy covers anyone that enters this home and works in this home, and that the homeowner consents to whatever. I don't know how that language would work or even how to make it legal, but that's one idea, is to cover it in the terms of the contract, right? I also think that if you have done those things necessary, where you put labels around the premises that say private property, then you have invoked your right to privacy as an employer in the course of your employment there, right? And so even though you can't invoke privacy over somebody else's property, I do think you can invoke your rights to privacy as a person, as an employer working in a private space, right? And you should, even if it doesn't hold up in court, you still should do it, right? So, obviously we can do more legal research around that invocation of privacy, but, if it were my own personal home, there's no question you don't let anyone into the house or your business without a warrant into private space. Okay, so it authorizes ICE to enter certain particular places in your property. It may say that they have the right to seize certain documents within your company, including computers and laptops. make sure you document and write down everything that they take. They are supposed to provide you with what's called a privilege log after they do a raid and provide you with an itemization of everything they've taken. But you yourself should also make sure that you're documenting everything that they have as well. And they should give you time to do that. The judicial warrant has to be honored. You can't be like, nope, we're not going to consent. You will get arrested if you fail to consent to judicial warrant. So you definitely want the judicial warrant to not consent, but to allow them to do what it says. Let's see. An administrative warrant, on the other hand, is issued by the agency. It's not signed by a judge or a court. It authorizes, oh, and by the way, the judicial warrant, like I said before, they're usually, if it's gone up to a federal judge, there's usually some criminal activity associated with it, right? Either a long history of documented hiring of unauthorized workers that they're now going to pursue as criminal, even though they've only done it civilly in the past, they're now pursuing it as criminal, or there's some other criminal activity going on. Some of the cases I worked on is where, I did a proactive I-9 audit for an employer. In the process of doing that, realized that the same alien registration number was appearing on a lot of their I-9 forms. And there was actual document happening with the job site where they were actually producing documents in the job site. And so that obviously would be a massive criminal investigation. So something like that is where they're going to go take the effort to get a judicial warrant to go to the U.S. attorney and try and prosecute it. Most of these cases you're going to see administrative warrants. They're just coming out to do massive arrests, right? To try and find the documented individuals. All right, so it does not permit an entry into private areas without consent. So you should only allow them into your public areas, not into your non-public areas. You can legally refuse access to your private areas, and just politely ask the agents to tell them that you'll get back to them after you've had the opportunity to review it with legal counsel. That's just usually the best practice. Okay. Other documents you may be served are a notice of inspection. This is, usually they want to see your I-9s. So this is this is often random. Some of these are random. Some of these are complaint driven. I have even seen industries do this to each other as a form of what I think is illegal competition, where they report on other employers. And so an I-9 audit is basically they're coming and they're saying, we want to see all your I-9s for your employees. And that you usually have 72 hours to turn over all your I-9s. They usually want them for all existing employees and any employees that have been terminated in the past 3 years. And you'll have to match up your UITRs with all of your I-9s and make sure that you have an I-9 for each employee. And if you don't, then they're gonna fine you civilly for that. Once it becomes a pattern, in other words, if they come after you more than once, that's when it becomes criminal and they could potentially get a judicial warrant at that point. The nice thing about a notice of inspection is you do have time to prepare for it. You have 72 hours to get your documents together and turn them over. Any of you have federal contracts? No? Okay. One of the things that we often see is what's called a notice of debarment. So if there's any suspicion of bad activity, any federal agency can serve you with debarment, which basically puts you on a blacklist so you can't compete for federal contracts. And I see this a lot in more construction engineering and big massive construction projects where agencies will go after contractors for debarment, and that can be the most damaging of all the consequences. Debarment can be the most damaging because that's their whole business is federal contracts. So. All right, any questions on judicial versus administrative warrants?
Well, I apologize, it wasn't necessarily on the warrants, but I'm curious though, for the employer, what is their exposure relative to you're hiring people to work in the field, laborers? What are the minimum thresholds that the employer needs to clear so that they don't have exposure? Meaning, I've been there, it wasn't in Colorado, it was in Florida for many years. You get an I-9, you've got a copy of the driver's license, and I believe often a social security number. What is the employer's responsibility to vet that information as opposed to, hey, this is what I was given and this is what I'm submitting?
Yep.
So that if you find out subsequently that some of that information was bad and they show up on the job site with a raid, what's the employer's exposure and responsibility?
Sure, great question. It is, you apply a reasonable employer standard, okay? So you are not required to be a document expert. You're not an ICE officer or an immigration agent. So you're not an expert on documents, and you're not required to be or expected to be. What the law says is that when somebody presents to you a document, you must take the document, you must physically examine it. You cannot accept a copy. You must actually physically examine, or whoever fills out the I-9 form, it has to be the one to physically examine it. And you must determine that the document is genuine and it reasonably relates to the person presenting it. Okay, that's the legal standard. It's genuine and it's reasonable. You are not required to search databases to make sure it's real.
So if the employer can demonstrate that in good faith, they did their due diligence, they're probably gonna be okay?
100%.
Okay,
Yes.
thank you.
So the way that the I-9 works, and this is important for what we'll talk about in a little bit, but there is an employer section and then there's the employee section, right? So the employer section has to be completed by the employer. The employee section has to be completed by the employee. On or before the first day of employment, the employee has to complete their section, right? So you can hire somebody, have them fill out their section of the I-9, have them present their documents 10 months before they are employed. It just has to happen on or before the first day of employment. And they're given 3 lists of documents that they can present. You cannot tell them which documents to present. You must let them decide which documents to present. Because if you only accept green cards, that's discrimination. If you only accept US citizens, that's discrimination, right? So you must allow them to present whatever document they want. List A documents are documents that establish both identity and work authorization. So if they present a List A document, your job is done, that document is sufficient for everything. That's like a green card, a work authorization card that has a photo on it, those kind of documents, passports. A List B document establishes identity, and a List C document establishes work authorization. So oftentimes people will present a driver's license and a social security, which is identity and work authorization, right? Those are the 2 documents that they'll present. But they get to choose, right? And so once they've done that and filled out section 1, the employer must complete section 2 within 3 days of the start date. And what they're doing is saying, I've looked at these documents, I've filled in the information showing that they're legitimate documents. Here was the start date, here's the date I completed it, and they put it in the file. I used to not recommend that employers copy documents, now I do. I do think it's good to copy documents because even if, it shows a track record for of what you accepted. So I actually do advise employers now to do that. So you take that document, you copy it, and you put it in your file, and that's it. Your job is done. Unless the document that they presented has an expiration date. In which case, you should tickle it to remind them about 6 months before it expires that they need to do something about it. This is a little tricky area. I'm not going to go in the weeds on this because there are certain documents that never expire, like your green card never expires because it's an identity document, right? So your identity documents never expire, but a temporary work authorization card expires. You have to monitor that because if you employ somebody after it expires, it's actual knowledge that they're not documented. I-9s are a liability. So as important as creating them is destroying them. So there are retention and destruction rules. I'm gonna get this in my brain, it's really confusing, but it is 3 years from the date of hire or 1 year from the date of termination, whichever is longer. Maybe it's reversed, but there's a retention rule, and what I recommend is when somebody is fired, figure out where they fit in that formula and enter a reminder or a tickle system to purge that document when you get to that date. Because if you get an I-9 audit, you can't destroy evidence at that point. That would be a crime. So once you get audited, you have to turn over what they asked for. But if you've already destroyed it in conjunction with the retention and destruction rules, then it's not a liability, it's a liability that goes away, right? So very important. If you're doing an I-9 audit now, which I do recommend, a proactive I-9 audit, look for those things. Look for I-9s that you can actually destroy because you're eliminating liabilities for the company. Okay.
Follow-up question, what does this look like for dissolved businesses?
It depends. If it's a successor in interest, So in other words, if the surviving entity took over the assets and liabilities of the previous company in the buy-sell agreement, then I-9s are considered a liability and the new company assumes them.
Okay.
If it's a strict asset purchase where they just purchase goods and no people, or it was a rehire situation, then there's no liability for those past
Okay.
I-9s. In your kind of industry, if you're in a merger or acquisition situation like that, I highly recommend that you get immigration counsel as early on in the buy-sell agreement process as possible, because you may be in a situation where employers are advising you to treat it as a complete new hire situation, right? If you know that you're inheriting a largely undocumented workforce, you want to treat that as a new hire situation so that you can control what documents you're taking in and who your workforce is that you're assuming. And so always in M&A situations, it's good to have immigration counsel as part of that discussion of the buy-sell agreement. Okay. So in general, what are an employer's rights during a worksite investigation? So as we said before, ICE needs a warrant to arrest a person. However, individuals can be arrested in public without a warrant if they have evidence that they've committed a crime or are about to commit a crime, right? That's really tricky, right? Because technically, being in the country unauthorized is not a crime, it's a civil violation. But there are certain circumstances where being here undocumented is a crime. So I'm having trouble wrapping my mind around a situation where an officer would not have a warrant, but also have evidence that a person committed a crime, unless they're in the process of committing a crime. That's right. Anyways, always ask the officer if they have a warrant, review the warrant. They have the right to perform the activities covered by the warrant, and it will be very specific. If it's not judicial warrant, you have the right to refuse to consent. They do not have the right to search your person. Okay, so they can't, in the process of a worksite enforcement, say, we want to pat you down, unless they believe that you have weapons. So theoretically, they can say, well, we're just checking for weapons and pat you down, right? I haven't seen that happen in a worksite investigation, but theoretically, they could do it. If they do, just make sure to say, I absolutely do not consent to this. It's beyond the scope of the warrant, and I don't consent to a body search. In all circumstances, you should not resist arrest, but in all circumstances, it's important to say out loud that I don't consent to search or question. You have a right to request a lawyer to be present before interacting with agents. Obviously, if they show up at your worksite, that may be very challenging, but I have been able to be present with clients through FaceTime, where they've said, can I have my lawyer be walked through with FaceTime? And so we just get on FaceTime and I observe what's happening on FaceTime. So even if your lawyer can't be there physically, there may be opportunities to have a lawyer there virtually. If you're being arrested for a criminal matter, you have a right to counsel provided to you at no cost. You have a right to public defenders. If you are being arrested for an ICE matter, you have a right to an attorney, but you have to pay for it because it's considered civil. It's not within immigration proceedings. You have a right to a lawyer, but you have to pay for it. This is important. In Colorado, you do not have to show ID or other identity documents. Let me put a caveat on here. So there's a Supreme Court case we'll talk about. I'm going to go to this slide because actually I think it's the Supreme Court in 2004 held that a state statute can require a suspect to disclose his or her name. So right, we started with the proposition that you don't have to talk to an officer. There is an exception under Supreme Court jurisprudence that says that states can require you to produce your identification to an officer. And so in the state of Colorado, if you're stopped by, quote, a peace officer who suspects that you are involved in a crime, you are required to provide your name, address, and ID if available. If available. So I think the interesting pieces here that as a lawyer I immediately think of is, well, what's a peace officer? Does that include federal agents? I looked into that. Anecdotally, it seems like, without doing a ton of research, it does seem like federal officers in the state of Colorado can definitely go through the peace officer process to be registered as a peace officer. But there is a process. And if they haven't gone through that process to be registered as a peace officer, theoretically, that they're not covered by the statute. Also, who suspects that you are involved in a crime, right? So, you know, this probably wouldn't get challenged until after, but if you were looking to quash an arrest, the officer would have to prove that they thought that you were in the commission of a crime. And if so, then you have to prove your name, address, and ID if available, right? So if your ID is not available, you can say, I don't have my ID. And it's different if you're pulled over for driving. If you're pulled over for driving, the officer can ask you for your ID, your name, your driver's license, your name, and your registration proof of insurance. So driving is a little different, but if you're stopped on the street, those are the things that provide. So going back to this first slide, in Colorado, you do not have to show ID if it's not available, right? So if it is available, you have to show it. There's another thing that I think is important here, however, and that is what I just talked about is everybody, but non-citizens under the law are required to have proof of their status in the country, their registration in the country. So if you're a non-citizen, it is a misdemeanor, federal misdemeanor, to not carry proof of your legal status, okay? Prosecuted as a misdemeanor. So you have this rub, right? Here's one of these areas where it gets a little tricky because if you have an ID and you present it, on the one hand, it may help you because it's proof of your legal status in the country, right? And so that would be very compelling evidence to an officer to show that you're in the country legally. If your ID doesn't demonstrate that, then it's not going to help you. Right? It's not going to help you and it could in fact hurt you if you turn it over and they find out you're not in status. Another tricky little nuance to this is one of the things that this administration has done is they have expanded what's called expedited removal to the interior of the country. So in the past, if you got caught at the border, within 100 miles of the border, and you don't have proof that you physically lived in the country for 2 years, they could issue an expedited removal order without due process, without a hearing before a judge and send you out of the country. They can now do that everywhere in the country. So one of the tricky issues here is if you're stopped by ICE, how do you prove that you've been in the country for less than 2 years so you avoid being taken into custody, right? So you see this, the rub here is that on the one hand, the law kind of requires you to have proof of your status and your in order to protect yourself. On the other hand, that same proof could hurt you, right? So, you know, I don't have the right answer for this. I think my best answer is if your people are in the process of getting regularization or they have any sort of document and have proof that they've been in the country for 2 years. Okay. Another little nuance to this is this administration, there's a statute that goes back to 1952. It's actually a good idea. It's called registration. And the idea of this statute is that when you go to the Department of State to get your visa, the Department of State should register you so that we know who's in our country. Sounds like a great idea, right? So we haven't done that since 1952. Never done that. And now we have millions and millions and millions of people who never registered. And the government's like, this statute could be really effective. So this administration is employing a 1952 statute that's now requiring everyone in the country, whether they're documented or not, to register. And when you register, you have to tell them your status or your undocumented status. You have to tell them your address, where you live. And failure to do it is a federal misdemeanor. It's a crime to not register, okay? But if you register, you're going to get deported. Like it's literally giving them your address and where you live and your status. So it's basically putting you on the radar screen to register. So, you know, this registration thing is really tricky for immigrants. It's interesting sort of from a policy level. I'm just gonna put on my policy hat for a minute. The purpose of this registration requirement is so that we know who's in our country, right? And that's a good thing. And even with the best of intentions, forcing people to register now is probably a good thing. It has good intentions, but it's having the opposite effect.
Yeah.
It's pushing people further and further and further into the shadows. It's actually creating more undocumented population than fixing it because nobody's signing up. Nobody. There's, you know, it's in the thousands at this point. So just a little policy side. Okay, all right, we talked about Colorado. Just a couple of other things. Don't run away, obviously, if officers are approaching you. That gives them probable cause to come after you. Always ask if you're free to leave. In any situation with any sort of police officer or federal officer, one of the first questions should be, am I free to leave? Because that forces an officer to answer the question yes or no. If the answer is yes, well, thank you, have a nice day, and turn around and leave. If the answer is no, then you're either under detention or arrest, which means that the Constitution applies to you at that point, right? And so that's one of the most important questions you can ask in a situation where you're having an encounter with an officer is, am I free to leave? If you're detained, you should ask for an attorney. And that's as simple as the interaction needs to be. Am I free to go? If yes, leave. If no, I'd like to speak to an attorney. Simple as that. And then state out loud, you're invoking your right to remain silent. The ACLU has really, really, really good know your rights cards. They're these little red cards. I don't know if you've seen them yet, but they're everywhere, and you can write to the ACLU and ask for them. One of my pieces of advice to employers is you have to be very careful about the advice you give to employees when a raid starts or in anticipation of a raid. If you know it's happening, you can't tell employees don't show up for work. Or, by the way, ICE is going to be here tomorrow. That's obstruction, that's harboring, that's shielding them from detection. But you 100% in advance of any sort of ICE warning can provide know your rights seminars. You can provide them those red cards. You can you can let them know about their right to an attorney and their right to remain silent. If you're doing those things proactively in advance, that's perfectly legitimate. And so one of the things that I've told employers to do is write to ACLU, get a bunch of those red cards and hand them out to employees to put in their wallets. If they get encountered by ICE, all they have to do is turn it over, right? Just hand it over to the officer. Let's see. All right, any questions before we move on to things that employers can do proactively?
Jeff, what's the upstream liability? So in our world, a lot of times with the GC and we're working with subcontractors, trade partners, and they have to workforce.
Yeah.
So what if it's your sub, if you will, that is, I guess their focus is on the investigation and inspection.
Yeah. Okay, so the ICE audit is not, well, it depends on, the notice of inspection is going to tell you what employer they're looking for, right? But there's Walmart, there's a very famous Walmart circuit court case where Walmart tried to avoid I-9 liability by only hiring contractors. And they found that that was unauthorized, it pierced the corporate veil, they went after Walmart directly, even though they were all contract employees. So my concern with this scenario is there is a way to handle this, but it has to be clearly outlined in your contracts, from your master contract down to your subs. So you start with the master contract that says all employees that work on this job site must be cleared through I-9. I don't know how the language is,
Sure.
but right, like either must have a documented I-9, must be authorized to work, and potentially must be E-Verify employee, right? If there is a E-Verify employee. And then you make all of your subs do that as well. And to get to Rusty's point about if there's an ICE audit and they come in and take away a bunch of employers, put mitigation clauses in the contract, right? If they don't do that and they have undocumented workforce and there's an ICE audit and they take all those workers away and you can't complete the contract, make them right? So if they're a sub and you're the master contractor and your sub loses their contract and they lose their workforce, and you told them, well, you know, the workforce, they would be protected. Does that make sense?
Yep.
Does that make sense, Rusty?
Yeah, it sounds to me like it's language that needs to be crafted in our particular case, inserted into our master subcontract agreement, which governs all the rules of the road for our subcontractor contract relationships.
You know, obviously you can't control all of your subs and what they do in their hiring practices, and probably you don't want to. Here's where it gets a little tricky, right? You probably don't want, you don't want to take on that legal obligation, but you definitely want to have it in your contract that you expect them to do it, right, to protect you. So, all right, so that's one of the important That's a great question because that's like an industry question that I would not know unless you asked. So really good question, but definitely gets to the issue of how you protect yourself as an employer. Most important piece is to have an action plan for all of this, right? So have a protocol in place, a documented protocol in place. Why? A couple of reasons. Because if you're accused of doing anything extraordinary or anything, obstruction or anything like that, to be able to point to an actual policy and protocol that you have in place is a good defense against an argument that you messed things up or did things illegally, right? So having a documented policy and protocol, it really just kind of goes through what we just talked about, right? From step one, what is a public space, what is a private space? You want to put that in, and then your employees need to be trained on which parts of the business are public and private. And then it needs to go through, on first contact, what happens? On first contact, the person takes the warrant, they get the badge, the ID, they document it, and then they get on the phone and they call whoever it is that needs to come inspect the warrant and walk around with the person. And then the next piece would be contact legal counsel, get legal counsel involved. Then the next piece is look at the warrant, figure out where they can go, right? So all these policies that we talked about, putting it in an active document that goes through the process of what you need to do when it comes to the website. So some of the things you'll want to, you want to say at the very beginning of the document, ABC company is fully compliant with all immigration laws and worksite enforcement laws under the Immigration and Nationality Act. B, our company also is very concerned about the integrity of and security of our company and the privacy of our employees. So you lay out those two factors at the beginning. Those are your two founding principles. We're going to be compliant. We're also going to be protect our employees. And then you lay down the protocol. Things that should be included are who is authorized to speak on behalf of your company. That should be clearly laid out. Who has the authorization to accept a warrant, who has authorization to engage with an ICE officer, who has authorization to sign off on the warrant that they've been served. That needs to be clearly laid out, and no one else should have that authority other than inside policy control. The policy for inspection of the warrant, documentation of the officer's ID, public-private spaces policy, a policy down regarding prohibiting anyone from shielding them from detection. So I think you need to clearly when I do these, I draft out the statute for harboring and obstruction, and I lay it out there, and I make it very clear, like, don't do anything that comes anywhere close to doing this, right? And then lastly, a phone tree with, this person calls this person, this person calls, so all people that need to know are contacted within minutes of this happening. And that's all I have. I know it's a lot of information, and a lot of this is probably going to continue to develop. So I'll send this PDF. I'll send this around as a PDF. My email is jjoseph@bal.com. jjoseph@bal.com, and feel free to reach out to me at any time with any questions, or certainly if things develop. So.
Jim, thank you.
Any questions that people want to take offline?